The next program that we're going to be dealing with is the topic of, it's a panel discussion. Is South Africa and cybercrime legislation aligned with the changing landscape? I mean, from the presentation that we had now, we see these things are changing. We are navigating, turning turns. It's very, sometimes you don't know whether you're going or coming, but we need to persevere, right? We need to make sure that we remain resilient, we drive the economy, we are safe. That's why we talk resilience these days and no longer talking security, because we can't, it is not a matter of if, it's when, but it is a question of when it happens, how do we continue navigating and working. As the panelist is coming on stage, I'd like to call Koketso and Lucien on stage, and maybe as they come up on stage, just to mention that South Africa is one of those countries where cybercrime is really high. It is estimated that we lose about 2.2 billion on cybercrimes in South Africa only. 2.2 billion is a lot of money. Some of companies that are running don't even make that turnover. Welcome on stage. I'm just going to introduce my panelist. I believe the other panelist should be online. I'm not sure if she got sorted. I'll start with introducing Koketso. Maybe just to mention again, October is a very important month, right? It's a month where we protect, it's a month where we want to preserve the world. In October, it's also a breast cancer awareness month. In October, we run a girl child month. In October, it's also a stop the hunger month. So October is a very important month, and I think, so I'm gonna start by introducing the lady, Koketso. Koketso is an attorney of the High Court of South Africa, who provides multidisciplinary legal consulting services, primarily focused on litigious and commercial matters. Koketso is a certified trademark attorney and is a fellow of the South African Institute of Intellectual Property. She has been recognized by Best Lawyers, a peer-reviewed legal guide for her expertise in intellectual property in South Africa. Koketso is passionate about enforcement and commercialization of intellectual property rights in the arts and serves on boards on the Visual Arts Network South Africa as its chairperson and the legal officer. Let us give her a round of applause. I think we are in the safe space, right? If you believe you've created some IP somewhere, you want to, she's your person. And then let me introduce Lucien. Lucien is not new to us. I mean, we always have Lucien when we have our gigs. Lucien is a managing director at Pukube Pierce Masitela Attorneys, a commercial law firm in Johannesburg. He focuses on commercial and regulatory aspects of the telecommunication, media, and technology. He covers matters such as commercial transaction, satellite frequency spectrum, license application, information security, data protection, and fintech. He has been practicing law for 27 years. We are in safe hands, right? So let's just start with this very important discussion. Are we ready as a country? You know, tech is evolving, things are changing every day, but at the same time, I think we live in a country that we are very fortunate. We are also very aware of what is happening. There are laws and regulations that are trying to help us to navigate these things, and so that we navigate within the ambits of the law. The cybercrime law enacted in 2020, does it protect us? Maybe as a question to both of you, let me start by saying, let's maybe briefly unpack it for us. What does it mean? How should we use it as practitioners in the field, and or as citizens as well? I'll start with you, Koketso.
Okay, thank you for that. I'm going to move a little bit back because I feel like I'm blocking Lucien, and I want it to be a discussion.
Sure.
So my interaction with the Cybercrimes Act has been quite limited. It's obviously within the scope of intellectual property law. Can the people at the back hear me? Because if you can't, just say no. You can't hear me? Oh, great, fantastic. Thank you, thank you. And so I think from a broader perspective, what the Cybercrimes Act intends to do is to secure or focus on information security. But more than that, if I can just give a little bit of background, insofar as cybercrimes are concerned, our legal framework did not have a specific statute that deals with cybercrimes. And so for a very long time, we relied on the common law, criminal common law, to prosecute and investigate crimes that happen online. And then later on, for about 2 decades or so for now, we've been relying on the Electronic Communications and Transactions Act, ICTA. So for a very long time we had that, but what's very wonderful about the Cybercrimes Act is that what it does is it codifies cybercrimes all in one consolidated document. And it also creates new offenses because, as Dr. Sylvia correctly stated, we have to be agile in this particular space. There are new activities that happen, and i.e. new crimes. So therefore, the cybercrimes comes in and says, okay, this is what hacking is. This is what cyber extortion is, etc. So that's really what the act is about in a nutshell, yeah.
Great. I think, Koketso's done a good overview. What the act also does is it covers a whole lot of areas that previously lawyers like ourselves were able to take advantage of. The one example I always give is of a very innovative lawyer many years ago who, when his client was on trial for piracy, in other words, one of those Pirate Bay type cases where information was, or videos were taken and copied and sold, etc. And the lawyer was, but my client hasn't stolen anything, it's still there. So the point is
and they're right, legally,
yeah,
they're quite right, yeah.
Absolutely. So what the Act does is it provides for situations like that. It says even though you can claim that it's still there, the fact that you've taken something, copied it, and put it somewhere else, that is a crime in itself. But it goes further. It deals with crimes that, as Koketso says, were not codified properly before. You might remember during the very sad riots we had a couple of years ago where people on Twitter, X as it's now known, were instigating riots and instigating looting, etc. And the Cybercrimes Act wasn't in force at that point in time. And it would have been very difficult to prosecute those people for incitement. But what the Act now says is that if you're going to be inciting people using data, in other words, something like X, etc., those crimes can be prosecuted as well. But it goes further because we weren't properly capacitated. We had great, cyber police units, if you want to call it that. But it now mandates the government to set up colleges that are going to train specialist police in cybercrime. It mandates the government to keep statistics about cybercrime. So it covers a very broad spectrum of issues which hopefully in time we will be able to make use of. And I know that there might be cynics out there who are saying, oh, not another law and it's never going to be properly implemented. We've got the best laws in the world. But when it comes to implementation, we're not. Let me tell you that it is going to come right. Take the information regulator under POPIA. Yeah. They started very small, and of course now, if you're dealing with the information regulator now, they're showing their teeth. So this law is going to work.
Sure, thanks. While I still have you on the mic, is it comprehensive enough, though, to address to address some of the emerging cyber threats and technologies where you can be sort of scammed by a thing?
Yes. So what's interesting is it's drafted very well and it's drafted very broadly. And what immediately comes to mind for me is what Nathan was talking about, using AI to commit a crime. And I don't know whether this is an urban legend or not, but I saw it on a credible news site. Last year sometime, somebody was scammed. Basically, an employee had a video call with who he thought was his boss, who then authorized the transmission or transfer of 25 million rand from one bank account to another bank account, not rand, dollars. And he did it. And of course, how that was done was apparently using a deep fake. So that, of course, I imagine would involve some artificial intelligence. But what the Cybercrimes Act says, it has a definition of something called an article. And broadly it says if you use an article to commit a cyber offense, then you can be convicted under the Act. And that definition of article is broad enough to cover the use of artificial intelligence as well. So if you use AI for purposes of cybercrimes, you're certainly going to be able to be successfully prosecuted under that, depending if you've got a good prosecutor.
Sure.
No, that's very true. And I think I like the broadening of the term article, because a lot of people used to hide behind that veil. So it's quite a nice tool, because we can pierce through that and you can actually also be liable.
Yeah, sure. Let's talk about sexual harassment, online harassment, cyberbullying, spread of misinformation, especially in the context of social media. Is the Act protecting us? And I'm very passionate about protecting, GBV staff and protecting women. Is the Act adequately addressing issues of online harassment and people sending other people's nudes and stuff like that?
Dr. Sylvia, that's a very, that's a very interesting question. In my view, and oftentimes, I would say probably most times, is you never actually look at an act by itself. Acts, pieces of legislation are used together like a puzzle to bolster each other where the other one is not, doesn't make provision for it. So what I mean by that is if the Cybercrimes Act does not specifically deal with social media crimes per se, there are other pieces of legislation that you can use. So for example, if we even start very, very small before we even get to the law, because let's be practical here, social media users, nobody really wants to talk to lawyers. We're like dentists, right? You only really talk to us when it's critical. So the particular social media platforms themselves have policies and rules. So if you're unhappy about something, of course, you can report it and you can use. So we've got that first tier. The second tier we also have is then under the Electronic Communications and Transactions Act, because you've got the takedown notices, which are applicable to ISPs. I do know the Human Rights Commission did issue a charter, social media charter, and the aim of that charter is to essentially provide guidelines for the use of responsible, content on social media platforms. And then the other one, because you were mentioning GBV, you could probably also rely on the Harassment Act. I'm just calling it the Harassment Act, but it's a very long term. And you can also get a protection order for that, or actually ask for a specific thing to be done when you are approaching the magistrate for an order. So yeah, there are a multitude of legislation or legislative pieces that can be used in conjunction with the Cybercrimes Act. Yeah.
Thank you. Thanks for unpacking the Act. Maybe let's just dive deeper into, is it enforceable and how the judiciary really handles that, right? How can the reporting and the investigation be improved to ensure that victims receive timely and effective assistance? And I think maybe sitting here, we might not be unaware of many crimes that are reported. And if Lucian, if you can take us through that process, how can it be made easier so that we get some enforcement? We are appreciative of there's an act, there's a way in which we can deal with these things, but the enforcement and the speedily resolution of these things, what can we do as practitioners if we found that somebody hacked us and almost putting our jobs into jeopardy?
Yeah, I think back to a time a couple of years ago where I had and this is to complement the Act from where we come from. I had a fender bender and was at the police station to report this little accident, and I stood there signing the affidavit, and I overheard a conversation of a woman who was reporting a romance scam. So for those of you who don't know, a romance scam is effectively where you meet someone online and you fall for them, and they then effectively exploit that relationship to extract money from you and eventually run off with whatever you've given them. So the woman had discovered that this was a romance scam, and she was there to report it. And she was dictating her affidavit or her statement to the police officer, a young fellow who looked like he'd just come out of college. And as she was sitting there, her phone rings, and she says to the young fellow, "It's him. It's the guy I'm talking about here." And do you know what the police officer said? Instead of, I'll tell you what he should have done. He says, "Tell him to call back later, we're busy." So of course, the question he just asked before is, where is this guy? And she said, "I don't know." So what immediately came to mind was, surely they could have traced him from the call. So that is the point. The point here is that we have people currently who are not sufficiently qualified to implement a very, very good act. And it makes provision, as I said earlier, to train more investigators, more police officers in this specialized area of the law. And in time, certainly, we are hoping to have officers where you go into a police station who will be able to address this. But of course, it goes further. It goes into the actual investigation of the crime. And what the Act has done is it recognizes that when it comes to prosecution, which is why I made the little jibe about if you have a good prosecutor earlier, it recognizes that mistakes will be made along the way. So what it has done is it has published or promulgated a very important regulation called Standard Operating Procedures for the South African Police Service. So what will happen now is that young police officer who was sitting there, having been trained on this process, would have known exactly what to do so as not to jeopardize the case. So we've got already, in terms of investigation of the crimes, we've got nice new regulations that have been put in place. We've got training for prosecutors, specialized prosecutors that the Act mandates. And we've got requirements for statistics to be kept so that we're able to monitor how much cybercrime is affecting us. There are provisions for specialized designated judges who can very quickly and who will understand what the issues are as far as cybercrime is concerned, to issue special warrants to allow these crimes to be investigated rapidly. And there are provisions for financial institutions and ISPs that require them rapidly, but in no less than 72 hours, to report offenses and cybercrimes. So you can see this is an all-encompassing piece of legislation that, when implemented, and if each person is properly qualified and does their job properly, we will have high levels of success in combating crime. It even extends to cooperation with other jurisdictions and how we can help each other, other countries in certain circumstances or emergency circumstances, to successfully pursue hackers and other malicious people.
Sure.
And Dr. Sylvia, I also wanted to say, sometimes we're so focused on just the criminal aspect and the prosecution aspect, but there is also another layer which is for the victims of those cyber crimes. So there are other pieces of legislation, for example, the Copyright Act, if somebody has now infringed on your software. So there are many other pieces of legislation for people who don't necessarily want to go the criminal route and lock somebody up, but they've suffered damages that people can also explore.
Sure, thanks. While we're on that, maybe taking it international or some regional perspective, right? We are trying to secure the world here. Are there barriers in enforcing this? In the example that you gave, if I've been romance scammed by somebody who's sitting in Germany, how do we deal with it? Are there barriers? Does our, what means are they for me to still get justice?
I wouldn't necessarily say barriers. I would call them hurdles, because I think we can definitely get over it. But one of the main challenges we had was around jurisdiction, because of course, as you know, it's a global community. You might have a hacker in Kenya and it's happening here in South Africa. So initially we used to have, our courts were reluctant to adjudicate over these matters. So the fantastic thing about the Cybercrimes Act now is that it does clarify jurisdiction. And for example, even if it partly happened here, or it's somebody who's a resident in South Africa, or a citizen, or is carrying on business, that way you can find jurisdiction and actually have matters heard here and decided on. So that's from an enforcement perspective. But also, and I think Lucian probably can speak more into this again, would be the enforcement element, because the Act has now given empowering provisions to law enforcers around the search and seizure and investigative powers. So there are a little bit of hurdles, but I think insofar as the Act is concerned, I think we're okay, but it's more the implementation, resources, capacity, skills transfer, etc. I would probably say we probably need to employ hackers onto SAPS's radar. They'll probably be good at it, yeah.
If I may add, yeah, Koketsu is right. You know, in the past there were difficulties regarding jurisdiction and whether you could in fact prosecute somebody. But we recognize that this, you know, somebody could be sitting anywhere in the world. So if you look at how the Act extends its jurisdiction, it talks about even if someone is hacking you from a ship, South African ship in another country, or somebody hacks a South African embassy in another country. All those aspects allow the government to claim that it has jurisdiction and then to ask another country to assist in extraditing that person to South Africa to face prosecution. So it really extends the scope of this act to actually touch people who might be sitting where they think
The
are safe.
untouchables.
Absolutely.
Maybe on emerging trends, Koketso, our IP legal system sufficiently protects AI-generated work, and if so, how? You know, and this goes into, AI works on data. I believe this is my data. Your model is created based on my data. Whose IP it is? How am I protected once you've then taken my data to create a certain model, to create something?
Look, I think there are a bundle of IP rights that people can rely on insofar as AI is concerned. But just to go back on AI legislation, and Lucien can correct me here if he differs, but as far as I know, there isn't any piece of legislation that's specifically, like an act that specifically deals with artificial intelligence, right? So then we use the other pieces of legislation, such as your Electronic Communications and Transactions Act. You'll use your POPI Act. And I also believe you'd probably even use the Films and Publications Act as well. So, but when we talk about the protection or the ownership of AI rights, let's start there. It depends on the work that is produced by the AI itself. So if we're talking about software, then at least we know we can rely on the Copyright Act and its provisions around ownership and how ownership actually vests in who. I.e., is it the creator, is the person issuing the instructions, is it the software developer, is the person employed? You know, there are many considerations around that. And then, of course, the Patents Act, depending on whether or not the AI creates an invention that's novel, provided it hasn't been disclosed to the public domain as yet. So there are a bundle of IP rights that one can use to protect or gain ownership over AI.
Okay.
Or AI-generated works. I think I should rather say that. Yeah,
AI-generated work.
Yeah,
okay.
correct.
You know, Kuda has encouraged us to use AI, but you know, AI feeds off us. Maybe let's move to POPIA and cyber crime. Lucien, are there specific amendments or addition that we should make to POPIA to ensure that we remain relevant in the face of evolving technologies?
Yeah, I think there are two specific issues that come to mind for me as far as POPIA is concerned, and they come from very practical experience and interactions with the information regulator in recent times. The first one, of course, relates to something that I'm sure each and every one of you can identify with. I know in the UK, for example, their information office, ICO, Information Commissioner's Office, has been issuing fines left, right, and center for direct marketing and cold calling, etc. And our information regulator here has been somewhat stymied by the fact that there is a little loophole in our law around how direct marketing occurs. And it's a pretty technical issue, but which they're trying to resolve. But basically, what I think the solution is to direct marketing is to actually change and amend POPIA to very clearly and explicitly deal with direct marketing. The people who try to sell you insurance, I'm not going to say the cell phone companies that call all the time. They don't. You know, somebody trying to sell you a car or somebody trying to sell you medical insurance. Those calls, you know, really need to be regulated, and at the moment they're exploiting this loophole. So the first thing I would think is we need to change POPIA to properly provide for that. The information regulator seems to think that they can use the law as it currently stands. I disagree with them, and I think they acknowledge that it's going to end up in court, and the courts will decide how this particular area should be interpreted. The The second aspect that interestingly came up in recent times, or last week in fact, interacting with the information regulator, is South Africa has lots of treaties across Africa and across the world where we are obliged in terms of those treaties to send certain statistical data, and in certain instances not statistical data, actual personal information. And what's interesting is in looking at some of those treaties and those agreements with other countries, many of them were written in the days before you even had Facebook, and people sent faxes. And a lot of those treaties don't have protection as far as the personal information is concerned. And I think that's where POPIA is lacking as well, because as we open up across Africa and become hopefully one big economic area, there's going to be a lot more transfers under those particular treaties, and we're going to need to provide for that. And I think that's where there are perhaps some shortcomings in POPIA at the moment.
Okay. Hint, hint. Those in insurance, cell phones, you can still phone us, right? And then you'll go to Lucian and say, he said there's a loophole in the POPIA. Kokotse, moving to citizen safety and awareness, right? How can public awareness be brought about so that people know about cybercrime, online safety, improvements, especially amongst the vulnerable groups like children and the elderly? I'm actually very scared of this two-pot thing. I think many people are going to lose their money. They're going to click on links thinking they are retrieving their two-pot money. Meanwhile, they are giving it to somebody. But how can we, how can we make sure that we remain safe as citizens and run the awareness, and especially the children and the women, who don't get to come to these conferences, who don't get to hear what's happening. And I know the school curriculum maybe tries to address this, but what else can we do?
Yeah, look, that doesn't sound like a legal question very much to me. Yeah, but I think, it's more about education. I think it's particularly when you're talking about children. And perhaps we could think more about cooperative governance, in the sense that the Department of Education should also be running drives around this. What is the school curriculum looking like around technology, cybercrimes, all of that stuff? I mean, of course, we have organizations like the Human Rights Commission, the LRC, etc., who also work with, the Constitutional Hill Foundation as well, who also work on educating the public around, these types of incidences. But I think also the regulators themselves can get into that and run drives or kind of some educational programs around that, because it's really about access. And I think most of us take it for granted that we'll have internet because we're in Johannesburg, but to go more into the forgotten provinces where technology is not so accessible and the internet is not so accessible, and actually do the work. Yeah, that's what I think.
Sure, thanks. I know it was not more of a legal question, but people want to say justice must be served. If I've been wrong, if justice is to be served, then we run to lawyers. Maybe just to conclude, and I don't want to call it a parting shot, but maybe your call to action for all of us in terms of being aware of the regulations and the acts that are governing the work that we're doing. Most of us who are in business to give certain services, we get paid for that. Who are working, we get paid to make sure that we keep the business running and we keep it safe, cyber safe. What would be your call to action to all of us in terms of understanding and knowing the rules and the regulations of the game?
Yeah, I think you've got to remain on top of things, and you've got to take our laws seriously. Time and again, we've been called in, and we encounter a client who now is sort of facing an inquiry, an assessment, an investigation. People's jobs are on the line, and it's only at that point that people realize should have, could have, would have complied with the law, done what is necessary. Kuda mentioned earlier a regulation or a standard that's coming into place on the 15th of November related to financial services. Now, you shouldn't be running around on the 10th of November trying to implement something that is going to take 6 months possibly even a year to implement. So my view is try and stay on top of the laws in the country that apply to your particular business. We've got laws like the Critical Infrastructure Protection Act. If I have to ask you, or any of you who's heard of that, there'll probably be 5 or 10 hands. But that likely applies to your industry as well, whether it be banking, finance, water, electricity. So have someone who's tasked with keeping you up to date on the laws, and as soon as they come out, be proactive. It's going to save you millions in legal fees. Lucian is not cheap, neither is Koketso.
Yeah, but I also think I was going to say maybe have Lucian's number on speed dial so that if you ever need updates, probably. The other, I think, also would be contract management. So it's also a good thing to have a look at your contracts, review them, particularly when it comes to getting indemnities in place, limitation of liabilities, even your dispute resolution clauses. You want to get something that's efficient, especially because it's such an agile space. The law may not catch up to it. So use your contracts as a tool, engage your commercial lawyers, make friends with your commercial lawyers, and get free advice over the phone. I mean, yeah, and that goes again to staying on top of things.
Okay, sure, thanks. I would allow 3 minutes for questions, which means 3 questions. Do we have any questions? Oh, yeah. Okay. Yes.
Can I just start the clock?
Are we invoicing for this, Lucian?
Freebies.
Okay, freebies.
Sure, sir. If you can maybe just tell us maybe your name and where you're from, and then pose a question. Do you have a shop steward voice? You can stand up and...
Oh, sorry. Yeah, Koketso nearly made me to hold back my question in terms of legal. It's not legal questions or something like that. Yeah, my name is Dumiso. I'm from the FSCA. FSCA is the Financial Sector Contract Authority. Yeah, my question is more on the cybercrime in terms of what the law says, whereby organizations pays ransomware to cyber criminals, and they come to public, you know, and making as if they haven't paid the ransomware or nothing has happened. What is the law says in terms of that, whereby they sweeping such information under the carpet? Thank you.
Dumiso, I'm not sure I understand your question correctly. Are you saying what does the law do in situations where people pretend as though they didn't receive the ransom? Is that what you're saying?
No, where they pretend they did not pay the ransom,
Yeah.
but they paid it.
Oh, that's actually a very interesting question. Lucian, I'm not sure what you think, but I think in the reporting provisions under the Cybercrimes Act, that would probably have to come out. But again, it would also depend on whether the matter's being currently investigated and prosecuted, because you don't really want to let certain information out that may still be a subject for litigation. So I think it's quite fact-based, but yeah, I'm not sure. That's an interesting question.
Yeah, look, I think to add to what Koketso says, I don't think, and I'm not aware of any law in South Africa that obliges you to disclose that you've paid a ransom to have your data restored. I'm aware that in the US, for example, there are currently proposals to put laws in place to discourage the payment of ransoms. Again, even there, it's not illegal. The Colonial Pipelines was the most recent one I'm aware of, where, you know, initially they didn't disclose and eventually they admitted to paying a ransom. Where I think there might be problems is you're not going to be fined for paying that ransom, but if you keep it secret, your stakeholders, the public, etc., are going to lose trust in your entity because you effectively have misled them. There's a second aspect as well, which is growing, and other jurisdictions are thinking of passing laws in this regard, and that is to make clear disclosures of the full extent of harm that you suffered as a result of a cyber attack. Mimecast and 2 others, I can't remember who they were, just paid fines about a week ago to the US government for failing to properly disclose to their stakeholders that they had suffered cyber attacks, first of all. I don't know about the ransom aspect, but I do think that in time you're going to need to disclose the full extent. One, the reputational harm, any losses that occurred, and if you paid a ransomware attack, ransom for the attack.
Yeah, and I think it can get a little bit, not embarrassing, but people are, particularly organizations, are quite reluctant to disclose that they've had, a data breach or they've had to pay ransom. So then it goes to, do I actually want to go and litigate and claim damages? Because then everybody's going to know. And you can't just simply rely on arbitration and confidence. So it is a bit of an unfortunate environment to trade in, yeah.
Sure. Thanks. We had 4 more hands, I think.
Thank you. Yeah, I think I'm the youngest even here. I'm from NTT Data. I'm a cybersecurity intern. And yeah, I just have one question since Kokes was just mentioned of free advice. I thought I could just ask you free advice from you guys. To just frame my question, so in 2020 while I was at university, there was a hackathon that was organized by Microsoft against GBV. So we did this solution for gender-based violence victims to capture their data on WhatsApp, to capture data of any physical harm or any incident that they have from their partner. So they capture it on WhatsApp. It gets saved on our database on Azure, like on cloud, and they can even delete the data that they store on our WhatsApp chatbot, and in case maybe their partner checks their phone, but that data is still stored on our database, and anytime they can request that data back, and then they can use that data to support them in a court case. Because when we did the chatbot, we saw that there's a low persecution rate for gender-based violence victims, mainly because of a lack of evidence. So we have that chatbot. We even won the competition back then, and we were recognized. But I'm a techie. I don't know anything about law, and me and the guys who did the solution, we are even looking into putting some IP on the project that we did, on the product that we have. Yeah, I'm a techie guy, and we're not really familiar with the law and all of that, and we're trying to navigate that now before even looking into making our product something that could be used publicly. So I want to ask, like, is there like support for this kind of model we did? Like, we capture, like, yeah.
Yeah, definitely, of course there is. And you and I probably can take this offline later on, but typically if there's a software that you've built and whatever, you've got the copyright over that. But then there are also other systems. So for example, if there is a name that you use for this particular, I don't want to call it a WhatsApp group platform, but you know what I mean. And it's an invented word, you could trademark that as well. So there are a bundle of IP rights that you can look into. But then, of course, you will need also advice on the protection of personal information, etc., and how the hosting is happening of that information. But yeah, definitely.
Sure, thanks. I think it's quite a loaded question, and let's take it offline. Let's chat afterwards. I'm even asking if the information is admissible in court. But let's move to the next question.
Good day, my name is Ashley Polser. I'm from the South African Transport Centre of Excellence. We are entering an era where we're going to be engaging with BRICS Pay. What kind of, or how much policy influences be readying themselves so that we don't fall prey going forward? It's going to start off slow, but it's going to be very big in the next few years. People are already starting to engage. What must we be aware of? What kind of policies, what kind of guidance must be put in place? Because we're going to be doing quite a bit of payments between businesses in China and businesses in South Africa.
Yeah, we have someone from the Financial Intelligence Center here.
That's what we were saying. We're like, let's get the FICA people.
Yeah. But I think what is probably critical, and jokes aside, you know, the Financial Intelligence Center is probably someone you should be talking to in terms of all the remittances and how they're going to occur. I suppose you should be looking at whether there are any exchange control implications that will arise as a result of this. Yeah, those are the ones that come to mind for me immediately. You know, talking to the SARB to see what impact that will have, because there's a range of regulations that you would need to and to be honest, I hadn't even heard of BRICS Pay today, so you've given me something to go and Google when I sit down. Thank you for that. But I think, yeah, look at those regulations, because there's going to be those transfers of funds across international boundaries.
We are really running out of time, 18 minutes over time. I'm going to allow the two hands that were here briefly ask the questions, and then there's still an opportunity to network and to ask further questions afterwards. Sorry, colleagues, to cut it short. I'm also very respectful of your time. We are 18 minutes over the time. Sure.
Thanks, Dr. Sylvia. Lucian Koketso, fellow lawyer here. I'm not going to ask you any questions that might cause a stir. It's more of a personal one, in your personal opinion. So we talk about ransomware, we talk about reputation and fines coming out. I mean, TikTok has set aside 1 billion rand. We know that. And it just seems, it keeps going. Like, when is it going to end with the fines? When is the buck? We know technology has to develop in order for us to move forward. But from a moral standpoint, I'd like to hear your personal opinions in terms of something going wrong. If you talk about PIA here in South Africa, we know personal liability and all of that jazz, but in your personal angle and what you've seen, and you've seen a lot, where does the buck fall when it comes to liability in terms of a human being behind a corporation and victims being on the other end of the line? I'd like to hear your take.
Look, I think in my context, it really depends on the client and their organizational culture, because some clients, obviously, they take, you know, employee relations quite seriously, and others maybe a bit more relaxed, shall I say that? So, and then the ones who care the most about their people will have policies in place around protecting them and also managing their reputation. So for me, I think most companies should be doing that, because the company is the people. And definitely there is something that entities, even though they may not have a legal obligation to do it, I believe that they do have a moral obligation to.
Yeah, I think just very quickly, it depends on the organization. I worked for a company once, a small company that was up against this really big monopoly. And we found out that this monopoly had this huge war chest. You spoke about 1 billion rand, simply to push the boundaries as far as it could, to pay fines because they were so small, knowing that it was going to make a huge profit in any event. So it all comes down, I think, to how that company, what its perspective is from a moral point of view, as you say. Does it want to do business ethically, or does it want to just pursue a profit at the expense of everything else? And thank goodness for me, many of the companies that we advise take the moral high ground, if you want to put it that way.
Okay, sure. Thank you. I think for me, just a parting shot is to say, let's know the rules of the games so that we can engage in a safe manner and be able to pioneer this resilience culture. Ladies and gentlemen, a round of applause for Koketso and Lucian.
Thank you, Dr. Sylvia.
Thank you.